evening, Mr. Chairman, Honorable Tribunal. My name is Tila Schwartz. I will be addressing you on behalf of Respondent Santos D. I will be speaking about the two procedural issues, namely the issue of security for costs, that claimant should provide security for respondent's costs, and second, the inadmissibility of claimant's claims. If it pleases the tribunal, I will begin with the first issue of security for costs.
Please go ahead.
Okay, it will be shown that contrary to claimant's claim, the tribunal has the power to order claimant to provide the security for costs at this stage of the procedure, and that it should do so under the certain circumstances or the specific circumstances at hand. The legal framework of this question stems from Section 21 of the contract. You can find it on page 10. Section 21 turns to the CAMC-CBC rules, which are the procedural rules that govern this dispute. Those are supplemented by the UNCITRAL model law, which we turn to once the CAMC-CBC is silent in interpretive matters. So if we look at Article 8.1 to the CAMC-CBC rules, we see it empowers the tribunal to grant provisional measures, and it does not limit them to a certain time during the procedure. We see, in the contrary, in Article 4.21, for example, which refers to new claims that are limited to the terms of reference. In the seminal book, Gary Bourne, International Arbitration, he elaborates on the rationale of security for costs, and it's essentially risk mitigation, meaning it reflects the risk allocation that claimant took upon himself to begin this arbitration, and therefore took upon himself the risk of any cost that would be affected. However, respondent is merely responding to claimant's initiation and therefore had not taken into consideration the specific risk. Going more into the concept of risk, the security for costs is given when there is a reasonable risk that claimant would not be able to pay the award rendered against him.
Oh, excuse me if
yes.
I will have to interrupt you. This is part of my job, so please take it in the right spirit. On the one hand, there is the interest that you are arguing, and of course we respect it. In the case that if the case will be dismissed and you will be entitled for costs, and there will be, in your argument, there will be no place where to take it from because they are in a financial, not best financial situation. But the other end is I would like to ask you two questions. One is goes to the evidence, and the second goes to the values. There is a principle in general law that is called access to justice. The gates of the court must be open to everyone, to those that can pay costs or give a kind of security or collateral to ensure their payment, and to those that don't have it, because otherwise in some cases some people won't be able to sue because they cannot cover the security. And so the question is, how do you balance that? This is one thing. And the second question is a paper become a newspaper, become a evidence in the court, or do we need more than that to come to base a decision that would say, yes, you must present some collateral, which maybe if we decide so, we will say also what should be the sum of it. And you were asking, I think, $200,000.
The estimate would be a minimum of $200,000.
Yes. So this is what I'm asking, the evidence question and
the balance.
The balance of interest, the weighing of the interest, and what should be the result as a result of the, I should say, the weight of the evidence you have, or the kind of evidence you have. Please.
Okay, Mr. Chairman, I'll answer both parts of your question. I'll begin with the evidence. It's true that we became aware of this risk through a business article on September 5th. However, this article was based on a press conference that was held on September 2nd. And this press conference was held by a legal entity, tribunal, and there it was stipulated that claimant had not complied with an award that was rendered against him for $2.5 million. So even though we became aware of this information through the business article, it's based on a legitimate legal source. So we would have been able to become aware of it perhaps otherwise, but it doesn't change the fact that the source is legally legitimate. I think even more so, the risk is a matter of a probability or of assumption. And I think that under the rules of provisionary measures, that's what we are coming to protect. We don't have certainty that claimant will not be able to pay this award, but we have some sort of risk and some sort of probability. And therefore, even if it wasn't the most strong source, perhaps the court would need to take it into consideration either way. As for the balance, it is true that also under the UNCITRAL model law in Article 18, the principle of due process is discussed, and it's applicable here as well. It seems that a balance could be found based on the test that the UNCITRAL itself lists, that's in Article 17, meaning we have certain conditions under which provisionary measures can be granted, and this guides the court, the tribunal, to stick to those rules in order to uphold this balance that you referred to. So if I may continue to set before you these claims.